Hello everyone, my name is Ananya Rajput, a law intern at LEXIS and Company. So today I am going to talk about terrorism and police. Now there can be no gainsaying that freedom of an individual must yield to the security of the state. The court have upheld the right of preventive detention of individual in the interest of security of the states in various situations prescribed under different statutes. The right to interrogate the detainees, culprits, or arrestees in the interest of the nation must take precedence over an individual's right to personal liberty. The Latin maximum salus populi est suprema lex means the safety of the people is the supreme law, and salus replicae est suprema lex means safety of the state is the supreme law. Coexist and are not only important and relevant but lie at the heart of the doctrine that the welfare of an individual must yield to that of the community. The action of the state, however, must be right, just, and fair. Using any form of torture or extracting any kind of information would neither be right nor just fair, and therefore would be impermissible and being offensive to Article 21 of our Indian Constitution. Such a crime suspect must be interrogated, indeed subjected to sustained and scientific interrogation determined in accordance with the provision of law. Now, he cannot, however, be tortured or subjected to third-degree methods or eliminated with a view to elicit information, extract confession, or drive knowledge about his accomplices, weapons, or anything. Now, the law prohibits torture, and confessions extracted by force generally are inadmissible in court. However, authorities often use torture during interrogations. In other instances, authority tortured detainees to extort money and sometimes as summary punishment. Now, the UN Special on Torture has reported that the security forces systematically tortured person in Jammu and Kashmir to coerce confessions to militant activity, to reveal information about suspected militants, or to inflict punishment for suspected support or sympathy with militants. In a 1996 report, the UN Special on Torture noted that method of torture included beating, rape, crushing the leg muscle with a wooden roller, burning with heated object, and electric shocks. Because many alleged torture victims died in custody and others were afraid to speak out, there were few first-hand accounts, although marks of torture often were found on the bodies of deceased detainees. For example, in February, there were protests in the village of Handwara and trial after a Rashtriya Rifles unit detained two villagers, allegedly tortured them for 2 days and then released them. There were no reports of action taken in any of these cases. Unlike in 2001, the Home Ministry again did not extend an invitation to the UN Special Rapporteur on Torture and on extrajudicial killing. Now, the prevalence of torture by police in detention facilities throughout the country was reflected in the number of cases of deaths in police custody. New Delhi's Tihar jail was notorious for the mistreatment of prisoners, with approximately 10% of custodial death nationwide occurring there. Police and jailers typically assaulted new prisoners for money and personal articles. In addition, police commonly tortured detainees during custodial interrogation. Although police officers were subject to prosecution for such offences under the penal code, the government often failed to hold them accountable. Torture usually takes place under two scenarios: in the course of regular criminal investigation and following unlawful and arbitrary arrest. For example, during criminal investigation, police frequently resorted to torture to extract information from suspecting while in custody. Now, it may be mentioned that the provision to award immediate interim relief under Section 83 of the Protection of Human Rights Act 1993 available to the NHRC, in addition to power under Section 18(1) to recommend the initiation of proceedings for prosecution or such other action as the Commission may deem fit against the person responsible for the violation of human right or negligence in the human prevention, can be some of the laws which can be taken against it. Now, NHRC took certain steps to put restriction to police, that is, on 14 December, the commission has required all district magistrates, superintendent of police to report any instance of custodial death or rape directly to the commission within 24 hours of occurrence. Then the commission recommended some amendments to put in certain restriction on police, like insertion of section 144B in an Indian Evidence Act, which introduced a rebuttable presumption that the injury sustained by a person in police custody may be presumed to have been caused by the police officer. The commission, and support of recommendation of ILC that section 197 of CRPC be amended to obviate the necessity of governmental solution to the prosecution of the police officer where the prima facie case has been established in one inquiry conducted by the session judge of a commission of the custodial offence. Then, in respect of custodial death cases, the present instruction of the National Human Rights Commission could be changed to effect that the state authorities could be instructed to also inform the concerned state human right commission of custodial deaths in respect to the particular state. Now, after adoption of UDHR, near about 57 years have passed. This period was the period of movement of human rights all over the world. This movement started as the reaction of world against Nazis' atrocities and large-scale violation of human rights during the Second World War. This helped in making human rights as permanent part of international law and domestic law. Today, the world menaced by weapons of mass destruction, nuclear weapons, widespread violence, terrorism, torture, and many more. Respect for and observation of human rights is the only hope which can save this advanced civilization from annihilation. Thank you.